Mr. Ellis scores a moderate 2, moderate 6, charged with assault, 4th-degree domestic violence, third within 5 years. Okay, does he need a public defender?
No, Judge, I believe he's going to hire.
Okay.
Judge, the Commonwealth is tendering a no contact order to have no contact with Jackson Starlings or her residents, as well as no weapons to include baseball bats.
So ordered.
The Commonwealth is also tendering a notice of motion to revoke conditional discharge on a 24F case. He has 365 days and was entered in January of this year.
So ordered.
Which is also for assault for domestic violence.
Okay. Do you happen to know if the victim is the same on the other two?
It's not, Judge.
Okay.
Your Honor, the Commonwealth is going to ask for a bond of at least $25,000 full cash to HIP if posted. The defendant has 5 prior convictions for violation of an EPO, as well as 4 prior convictions for assault in the 4th-degree domestic violence. He also has a prior conviction for possession of a handgun by a convicted felon. Based on the allegations, the Commonwealth does believe that he is a danger, not only to the community, but to anyone that he is in a relationship with.
You know his friend on him?
He doesn't have.
Oh, doesn't have. And Judge, what we asked the court to consider is 10,000, 10% if posted to HIP. I understand that Mr. Ellis does have some type of history, so we're not asking for an ROR. But I think that HIP would ensure that he's not, we're not asking for his releases right now, ensure that he's not going around this person. And also posting money is also an insurance that he returns to court, so we'd ask the court for that bond. Judge, I apologize. He does work, so I guess we would be asking for it, if the court grants that bond.
Well, in addition to his truly horrific record here of assaulting other people and not following judges' orders to stay away from people, he also has a history of assaulting people in other states. So HIP will not be an option unless he posts a $25,000 cash bond. So the bond will be $25,000 full cash plus HIP if posted. No contact with the victim or her residence.
Good luck to you.
Number 26, Aaron Johnson.
Mr. Johnson scores a moderate 2, moderate 5. He's charged with violation of Kentucky EPO DVO. Bond's currently set at $1,500 cash.
And Judge, I think it might be 2 counts.
Oh, sorry, I always do. Huh? No, I show 1, but maybe
it's 2 on the criminal complaint that was sworn out. Okay, so I think you just have a typo maybe on your report.
I didn't understand.
Yeah, you're right. The warrant says 2.
I have 2 charges.
Yeah, it's 1 case, but it's 2 charges in violation of the EPS.
Okay.
The Commonwealth is tendering a no contact order with Amber Pabst or her residence.
Just to be clear, sir, the 2 charges result from, they allege that you called her once and that you texted her once. That's why it's 2 charges. I'm not saying you did. I'm saying that's where the 2 charges come from.
I never spoke to us. I understand.
The Commonwealth is also tendering a motion to revoke conditional discharge for 2 cases from 2022. The defendant has 30 days and 365.
Okay.
And Your Honor, the Commonwealth is going to be asking for an increase in bonds to at least $5,000 full cash to HIP with posted. The defendant poses a significant flight risk. He has a conviction from October 2019 for escape in the 2nd degree, as well as another conviction from August of 2019 for escape in the 2nd degree. He has a significant flight risk, and a 3rd conviction for escape in the 2nd degree from 2017. He has a prior conviction for, I believe, assault in the 3rd degree.
I ain't never done anything violent in my life. I'm arrested 30 days off the 12 years. Come on.
Judge, based on.
You just mentioned MRS.
I'm sure.
And Judge, actually, after looking further at the record, I would ask for 10,000 full cash to HIP if posted based on the number of escape convictions. Another escape conviction from 2004.
I show one for an 08 CR, also guilty, 2 years escape second.
Yes, another escape in 2008.
I don't know if I've ever seen this many guilty escapes in my life.
He's a wanton endangerment first from 2007. And based on that and the fact that he is obviously violating court orders by continuing to contact the victim that he is not supposed to be contacting, the Commonwealth has serious concerns about
Even though the class A listed me.
safety of that victim as
Are
well
you
as
serious?
the
$10,000 bond?
And Judge, we would ask the court to consider something
Class A
less than
misdemeanor.
that. As he's mentioned, it is a class A misdemeanor. The allegations are a call and a text. One, he's presumed innocent, so I get this witness is making these allegations, but he is presumed innocent.
Please, I'm trying to change my life for real.
We are asking the court to consider a surety bond on this.
Please.
The fact that you can't control yourself right now leads me to believe what your behavior will be when you get out of jail. And it's not good.
I apologize.
And I think we still have to discuss counsel.
Yeah. Well, you want to ask him?
No, man.
He needs services of the public defender.
I'm sorry?
He needs services of the public.
Okay, we will appoint a public defender for him. I'm going to set the bond at 5,000 plus HIP if posted.
Judge, it's going to be in court 302 on June 21st at 9 a.m.
Is it Johnson? I think it's 303.
Oh, 306.
Yeah, let's go 303. The same date, June 21st, 9 a.m.
I think you're good.
I
said you're good.
So I have a $5,000 bond on a class A misdemeanor?
Yes, sir.
Thank you.
Yeah.
Well, Mr. Allen,
Really see.
do you, are you familiar with your rights or do you need me to read them to you?
I'm familiar with.
Okay. So he scores a moderate 2, moderate 5. He's charged with convicted felon in possession of a handgun, fleeing or evading police 2nd degree on foot, and harassing communications. Sir, do you need a public defender?
Yes, please.
Okay. What's wrong?
My eyes and everything, I can't. My eyes, I don't have my glasses. I can hardly see.
Okay.
Your Honor, the county will be asking for a written backfire order directing Mr. Allen to have absolutely no firearms. We're also asking for a written no contact order with Jennifer Filliard.
That's not my gun. That's her gun.
Okay.
1513 Clara Avenue.
And that's where I lived at with her.
Sir, you're not helping yourself right now.
Oh, I'm sorry.
These are the current orders on you from the court. And if you're going to tell me that you can't comply with them, then I can't consider letting you out.
No, I wasn't
saying. Well, then keep your mouth shut.
Yes, ma'am.
So, Judge, we're asking for that written backfire order, which would direct him to have no guns, no contact with Ms. Hilliard, her residence, any place of employment, and no third-party contact. He does have a parole violation to take up.
Oh, so he's not going anywhere. I guess that explains why you ran.
Based on the nature of the allegations, Your Honor, it's the county's motion to set the bond at 10,000 full cash. Plus HIP to get posted. I do understand that he's currently as a full misdemeanor, but obviously the county, meaning the county attorney's office, we don't have a role in that proceeding.
Mm-hmm.
And certainly we would have concerns for the safety of the alleged victim, given the text messages, I believe, that were shown to the officer about, I got you for real, or you're going to pay for betraying that promise, or you're going to pay for betraying that's a promise.
Yeah, I did see that it was a domestic, the culprit.
And Judge, given his moderate 2-score, moderate 5-score, we would ask the court to consider a $5,000 bond or HIP in lieu.
We also have an escape conviction. Looks like he served prison time, so
An escape conviction of prior.
That would 30 years. I'm sorry.
Ms. Mary, I can tell you we're going to do for 301 on June 21st, no matter what the court's decision is on bond.
I think 10,000 full cash plus HIP if posted is appropriate. With that parole detainer, I don't think the bond really matters because I don't think even if he posted it, he would get out. But I think that's what's appropriate under these circumstances for this record in this case.
Sorry, but
You need him still?
they can take it to him.
You need him still, or is he?
He's done.
He's done?
It's the first time he's been quiet.
Oh, really? Was he banging or what? Yelling?
You know, I wouldn't even threaten her or nothing like that. That wasn't even a threat.
Why is
That wasn't even
Is that a
a threat.
fake one?
Let's go.
No, I believe
Let's
it's
go.
not. Okay, well, never mind, you're fine.
She's been hard as criminal.
Yep. Okay. Go!
Hand me my screen box.
Now go.
Your Honor, yes, thank you. And Your Honor, my client tells me that she is currently on Social Security disability, not working, Your Honor. She's single, supports no children. She may have an older matter that's not been addressed yet somewhere, court matter. But Your Honor, she tells me that at one time she was living in a safe house for a while. And then there was a period of time where she was homeless. But Your Honor, she's assured me that she will appear in court. She's most concerned today in that she's got a dog at home alone with nobody to contact to take care of the animal. So we would ask, Your Honor, if the court pleases, for a personal bond or a bond she can reasonably expect to post, Your Honor, these not being crimes of violence.
For your matter from December, you're supposed to have been here February 7th, and you weren't.
Yes, I did. I believe that that paperwork must have went to Auburn.
Yes.
Maybe E-course. Yes, I didn't get any mail from that. So what I'm saying, I wasn't aware of the date.
You received a citation that day regarding your driving on a suspended license, correct?
Yes.
And what does it say on the paperwork that you received, the ticket?
You know what? I just thought that I was going to get something in the mail. I didn't even pay attention to it. I'll be honest with you. I didn't even read it. I just knew I had driving on suspended. And the reason why I have no license is the no insurance tickets. I have no insurance tickets during the time period when I was left from the safe house, when I was at the safe house. I was using the vehicle that my boyfriend was paying for. That's the person I left. I'm on relocation. I came to relocation through the domestic violence shelters. I worked with Avalon, and then I worked at Common Grounds.
Okay.
That's why I don't know people out here.
Just a moment. It's your responsibility. You received the ticket. It's your responsibility to contact the court. You didn't do so. You didn't contact them with a different address or anything else. So the fact that you didn't appear for your matter in February is not on the court. That's on you. I can appreciate you have a lot going on, but that's still your responsibility.
I apologize.
And who do you live with at the home, man?
Myself and my dog.
If you were to test today, what's in your system?
Absolutely nothing.
So you ever failed to appear in court in any other jurisdiction, ma'am?
I'm sorry?
Have you ever appeared in court in any other jurisdiction?
Yes.
Where?
Washington County.
And is that for the no insurance or is it for something else?
It's for open container. I think it's about 2 years old.
So why are you taking care of that, man?
I'm sorry?
Why haven't you
my life has been since I left since the safe house and I left my abuser. I haven't been the same person. There's no excuses for my actions right now. I have therapy and psychiatrists and stuff. I have that. Like I said, I've worked with my advocates and stuff. I'm just not. I don't really have an excuse. I just don't. PTSD, and there's a lot of things I'm dealing with that I don't think about things like my responsibilities and stuff that I should be thinking about. I don't have an excuse.
Okay.
I don't. I have not been in trouble since 2009.
Well, ma'am, not necessarily, because you have the open intox, you have the driving while license suspended, now you have this one.
Right. No, I know, but I'm just saying, like, in trouble. Like, you know, I've been doing a good life until I left my abuser, but I promised to show up for court.
You said since 2009, you also, ma'am, have a 2018 operating while visibly impaired.
Oh, yes, I did have that. I was on probation and I completed it for 1 year. Yes, I did. You're right. I completed my probation. You're right. You're right.
All right, based on your failure to appear, your other matters that you failed to appear on, the court wants to ensure that you're going to appear in these matters. And so we don't have to have another warrant issued for your arrest.
You won't.
The court's going to order on 232487 a $2,500 10% bond. Wait, ma'am, where is it you work?
I'm on SSI. I'm on disability.
And how long have you been on disability, ma'am?
Since August.
All right, as to 232487, based upon your previous failure to appear, the court wants to ensure you're going to appear in court. The court's going to order a $2,500 10% bond. In the event you post bond, you're not to possess or consume any alcohol or drugs unless prescribed.
How much is there?
And then the court's going to also order on 24783 $1,500 10% bond, not to possess or consume any alcohol or drugs unless prescribed. And then we'll see you back on July 3rd.
Can I address the judge?
Thank you, Your Honor.
What's that, ma'am?
Oh.
My dog, and I don't have any money until my 3rd of the month to get out. I won't be able to get out.
Ma'am, my responsibility as a judge is to ensure that an appropriate bond, that you're going to appear in court and to protect the public, the safety of the public. Those are just a couple of the factors that this court has to utilize in assessing a bond. You have failed to appear in this court. You have failed to appear in other courts. Therefore, the court's going to make sure you're going to appear. The court has, while I understand that it may seem as though it's a lot of money to you, ma'am, I'm not discounting that at all. Based upon the nature of the charges and the fact that you've previously failed to appear, this court has set a relatively low bond on both of these matters.
I don't. My dog.
Ma'am, you can make whatever phone calls that you need to make.
I don't have anything.
Ma'am,
I don't have anybody.
Individuals that you were with on both of these occasions, potentially those people, I don't know.
I didn't hear her. I didn't hear you. I'm sorry, Your Honor, I didn't hear you.
You have individuals that you were with on both of these occasions, so you can certainly perhaps try to contact those individuals. I don't know, but the court is the bond is set.
Which is how much is that?
150 and 250. I believe that's $400. No, $400.
That's correct.
What is it?
Okay, is Jason Hanley next? Is that who's next? Let's go off the record. This is the matter of the City of Wyandotte versus Christopher Canning, 24784, 24782. And so, counsel, your appearance for Mr. Canning.
Yes, Your Honor. Richard P. Serrano, P33828. I appear as I'm making counsel on behalf with my client. We appear via Zoom with no objection. And Your Honor, my client requires a formal reading in this matter, please.
Okay, Mr. Canning, your name for the record, please.
Christopher Canning.
Okay, I apologize. I didn't realize that you were Mr. Canning.
I apologize. I didn't know you were trying to address me. I thought there's somebody else.
All good. All good. All right. And so the court does have a complaint that alleges on June 15th at 6:11 a.m. that you did commit a larceny of a bicycle. The possible penalty upon conviction is not more than 93 days in jail and or a $500 fine. The court will also note that the other complaint on 784 alleges on June 15th at 2:36 a.m. that you, in the area of Emmons and 4th Street, did buy, receive, possess, or conceal stolen property. And specifically, I will tell you what that is, a red BMX bicycle. And the rehabilitative goal for that, the possible penalty upon conviction for that matter is not more than 93 days in jail and or a $500 fine. And just for clarification, counsel, it appears as though the first one that I arraigned your client on for the one on 2nd Street is a different bicycle with a complaining witness of Leroy Hall. And on the one from the 2:36 a.m. matter, it appears as though Tiffany Jana was the owner of the other bicycle. So there are two different offenses because there's two different bicycles that are alleged here, counsel. And so
thank you.
The court will enter a plea of not guilty, schedule these matters for pretrial on July 3rd.
9:15.
At 9:15 a.m. All right, counsel, as to bond.
Your Honor, my client is 33 years old. He tells me he's not on probation or parole, and he has no matters pending. He was forthright in telling me that at one time he did fail to appear for court. And at this time, Your Honor, he tells me that he's homeless, but he may be able to provide a friend's address where he's going to stay. He's told me up front that he may have marijuana in his system. He does not have a medical marijuana card. He tells me that he's requesting a vegetarian diet if he's held incarcerated. And Your Honor, these matters, the victims are strangers to him and alleged. And Your Honor, we would hope the court would allow him to get a bond that he can reasonably expect to post under the circumstances. He does not have any income, Your Honor.
Okay, Mr. Canny, when's the last time that you worked, sir?
I'm sorry?
When is the last time that you were employed?
Employee? That was about a year ago.
All right, why do you not work, sir?
It's been a really rough road trying to survive, get my ID. I lost my ID, trying to get settled into housing with Wayne Metro. And they're right next door. And just I'm hungry out here and trying to survive. Like I was trying to go get food. I got a backpack full of food that's probably gonna be thrown away. And we've been from Taylor to Dearborn Heights, Romulus, all over River Rouge to all over here. And
who's we?
My girlfriend and I, we kind of been in this together for like the last year since we met each other. And I got a job, and then it got really messed up because of the shelter that I was in, like the scheduling and everything. It was like either sleep outside in the wintertime and have a job, or don't have a job and be able to be in the homeless shelter. That's what the stipulation is. And so that's what happened with
when did you relocate down this way? Because it appears as though you've lived out in the city for a while.
What happened?
It appears as though you've lived in Traverse City for a while.
Sorry, oh yeah, Traverse City. Here, can I close it? I can't really hear.
It appears as though you've lived in Traverse City for a while, sir.
Yeah. I have been in Traverse City for a while. That was a long time ago that was a couple years ago. My family lived there. And we moved there from California, and I've been moving around from there a little bit. I've been like to a lot of places.
Right, well,
And
that's what this court serves, that you don't have any stable residency. You don't have any connection to the area. And so, let's see.
I do have a place over, but I don't have the address to, I don't know the address to it, but I know where it is, the street that it's on. And then like I have an address right here in Wyandotte. It's 2121 Middle.
2121 Middle.
Yeah.
And where is that, sir?
It's right here in Wyandotte.
Okay, I understand that, sir.
It's where I can get my mail and stuff.
Well, sir, that's the building next door to the court.
Yeah, that's what I was trying to say. The Wayne Metro.
Where do you don't have to address where you reside. You've stated that
Wait, what's that? To reside?
Right.
Right, that would be some the friends of mine that I know over that's over in River Rouge.
Okay, sir, what happened with your matter in Monroe?
That so like yeah, I had missed that court date, but like I was able to make it back, and then like they reset it, and then they said that they told me I had to go there in person. And I had no way to get there. So I finally was able to get there. I went there, and then by the time I got there, they were closed. So I had to come back over here to Taylor. So I had to ride a bike. It was like 3 hours, like there and back. And I did that twice. And
Mr. Canning, just a moment, please. Did you take care of that matter, or is it still pending?
yeah, no, it's over.
Okay, and what about Southgate? Is that one completed? Or
Where?
is that pending?
They're all complete. What did you say?
The one from March, Southgate. Is that all cleared up, or is that still pending?
Yeah, that's all cleared up. That probation. I think that was like 12.
Okay. Well, the court's going to note the following: that you have had a number of matters that are of similar nature regarding crimes of theft, felony burglary, Plead to misdemeanor larceny, breaking and entering illegal entry without owner's permission, dismissed out of the First District Court in Monroe. You had a felony burglary out of Dearborn, amended to disturbing the peace. You had
we've been trying to survive.
Please don't interrupt, sir. You have a burglary charge and damage to property out of the 28th District Court, which was reduced and pled no contest to. And then you have a larceny charge out of Grand Traverse County out of 2019. Amended to larceny. You have this matter, and you have a plethora of other matters as well. And so for those reasons, the court feels compelled to order a cash bond, because the court needs to protect the safety of the community, as well as to ensure you are going to appear in court.
I will appear in court, Your Honor. I promise. Like I go right here to the Wayne Metro that's right next door. It's the homeless shelter.
Based on the fact that you don't have any ties to the community, you've been moved around quite a bit, and the court is going to order on a bond of $3,500% on each case, with the following bond conditions. In the event bonds do not have contact with Leroy Hall or Tiffany Janow, you are not to return to their properties.
Please help me get a pure bond.
You are not to possess or consume any alcohol or drugs unless prescribed. And in the event you do post bond, you're to have a GPS tethered to the Wayne County Jail.
Okay. Like I don't think I'll have any way to get cash for the bond. And I need to get my housing from Wayne Metro. I'm in their program. I have a worker, and it's a program that gets you out of homelessness. And my girlfriend was helping me And it's been really crazy, rough road. Like, was this close?
Please
Close
stop.
to homelessness.
Please stop. After everything you have to say, you have a number of cases, a number of criminal convictions that are the same nature as these matters. And these two matters are a difference of 4 hours apart. And it's the same.
No, it was right. Can I explain? My feet have blisters.
No, sir, don't talk about it.
You cannot explain it. I'm not addressing the facts of this case, all right? Because anything you say orally or in writing can be used against you in court. So the court has ordered the bond. Those are the bonding and the conditions. The court will make a note on the file as well that you're requesting a vegetarian diet. Thank you.
Thank you, Your Honor.
All right, off the record.
So what is the bond? 30, you say 3,500 for both?
3,500 for both, yes.
On both.
So it's 7,000 altogether?
It's 10%, sir, so 350, so it's 700.
So it was 500 in person, how's 37? 7,000. Why don't you let me call my dad?
We filed a non-payment eviction against Mr. Phillips, and alleging essentially from January going forward that there's been no rent paid. There was now 2 issues that have been raised on a motion to dismiss, one of them being that a new lease was entered into in April of this year, and the second based upon the fact that there was a rental assistance check that was sent to Hampton Place apparently in March or so, but it was just for 1 month, and so the motion to dismiss is a waiver on both of those counts. I think other than that, it's a standard non-payment eviction.
Your Honor, may I address the waiver?
Mm-hmm.
Go ahead.
Were you finished, Mr. Dunn?
Yes, I mean I could go into the whole issue in a waiver, but since it's his motion, Mr. Chandler probably ought to go first.
Go ahead.
So as Mr. Dunn identified, there was an eviction filed in this case in March based on non-payment. A few weeks later in April, the plaintiff signed a new lease with my client, extending the continuance of his tenancy there until April of 2025. When they signed that lease, they waived. Under the case law that we cite in Daly v. Kelly, where the lessor, after knowledge of the breach, expressly or impliedly recognizes the continuance of the tenancy, they thereby waive the forfeiture. The intent of the landlord when they sign that is immaterial. And I know that Mr. Dunn has submitted some documentation from the Kentucky Housing Authority and other regulations wherein they claim that they had to do this. That is not so. What's contained within the regulations submitted is that a recertification needed to be completed to ensure that the unit could still be counted under their mixed use agreement as being one to a low income tenant. But within the regulation, even in the ones that Mr. Dunn submitted, the landlord still maintains their remedies to terminate the lease and seek an eviction. The issue in this case is that they waived those remedies when they signed a new lease with the man. So, Your Honor, based on that, today we're asking for it to be dismissed. And if we need to proceed into the nitty-gritty of what happened with the ledger, we can. What I understand is that back in February, the plaintiff and the defendant both signed an agreement with the neighborhood place indicating that rental assistance would be paid and accepted. And at some point, it sounds as though the plaintiff reneged on that agreement and took a check from the city government and decided not to cash it. Now, whether or not they've cashed it, I mean, they entered an agreement to accept that rent back in February. So we think the complaint's deficient because they're saying they didn't get rent that month. But our ultimate argument really is the waiver issue, that they signed a new lease continuing his tenancy, and the law demands that they have no remedy now and it should be dismissed. Thank you.
Mr. Dunn.
Your Honor, as to both of those points, let me address the renewal lease first. I filed just a section of the compliance manual of the Kentucky Housing Corporation, which is tasked with the responsibility of monitoring IRS section 2042, which has to do with tax credit properties and buildings. And according to their requirements on page 18, which is what I filed with the court, there has to be an annual recertification and where the income is verified based upon guidelines and such. And what happened in this case, when that was done, the result was that the amount of rent that Mr. Phillips was to have paid increased from $775 a month to I think it's $846 a month. And based upon that, then there had to be some form of new agreement, rental agreement, that was entered into reflecting the new amount. Again, this is all done pursuant to the agency's guidelines and compliance. It's a requirement, absolute must, that they have annual recertification. And again, this is federal law, which we believe which should override all other law in this situation. So we do not believe it is a waiver. It is a requirement that we had to do that, even though we were in the eviction process. As to the situation back in February, I think the agreement, and by the way, that agreement was filed by Mr. Chandler with his motion.
Yes,
it's titled, okay, entitled Landlord-Tenant Agreement. First off, that's a requirement that this agreement be there so that Mr. Phillips could then attempt to get any type of rental assistance, primarily, I guess, through Neighborhood Place. It starts off by saying that by accepting payment, the landlord accepts the terms of this agreement. So the question becomes, did they accept payment? The amount of rent that was owed at that time, including late charges and such, was just shy of $1,500, $1,486.80. Ultimately, Mr. Phillips was approved for essentially 1 month, roughly $775. That check was sent to Hampton Place. They were holding that check so that by the time they received it, the amount owed was actually 3 months, which brings it up to roughly $2,200 in rent, so that Mr. Phillips could have the opportunity to make up the difference and make the full payment. Ultimately, he could not do that, and then they sent that check back so that they did not accept any check from anyone, Neighborhood Place or Mr. Phillips. There won't be no canceled check because it was never negotiated.
Okay.
So we think the argument, the motion to dismiss on both counts, waiver based on the new lease and waiver based upon receipt of payment, both of them must fail, and we're entitled. Ultimately, we're going to be entitled to a judgment because I don't think there's any issue that Mr. Phillips owes, in effect, 6 months of rent now.
You want to?
I respond to reiterating the most important document in this case is the lease. And there was a new lease contract executed on April 2nd, 2024, after they filed the eviction, manifesting that Mr. Phillips is going to be permitted to reside on the property. They're free in the future if there's a non-payment breach of the current lease that they're under. They're free to exercise their remedies in that way. But any, additional material about why they entered into this contract is not reflected within the four corners of the contract itself. And it surely doesn't say, Mr. Phillips, the only reason we're giving you this here contract is because the feds are making us. And I would argue that the regulation side of it, Mr. Dunn, do not require them to enter into a new lease. It's only if he keeps living there, they got to certify that he's income eligible, which is not the same.
So, Mr. Dunn, I understand the annual recertification. That's something we deal with on a regular basis in this court. But I tend to agree. We have plenty of people who are facing the issue of needing to be recertified, but an eviction is pending and landlords don't do new leases. So I'm willing to let you brief the issue if you think that there are further regulations on point because I don't think what you have submitted to me answers the question. It answers the question of recertification. I don't think it answers the question of did they have to enter a new lease with the tenant? Unless you can point me to a specific section of it that says that.
I believe, well, let's put it this way. It's inherent, I believe, in the whole recertification process because it resulted in a higher rent being owed by Mr. Phillips, that there had to be something entered into to reflect that. And again, this is according to Kentucky Housing Corporation's guidelines, and they're interpreting and compliant. And monitoring compliance with the federal IRS statute. And the whole purpose of this is to have lower income housing for people. I believe that should override what the situation is so that we should be able to go forward here.
But your client chose to raise the rent, and that's why you're saying that a new lease is necessary.
Actually, my client didn't choose to raise the rent, Your Honor. It was because of the annual recertification process that the result of that was the additional amount of rent that was owed based upon all the information that apparently was supplied by Mr. Phillips. In other words, we did not just willy-nilly pull it out of the air that he has to pay some more rent each month. Again, this is all covered with the recertification process, which is a necessity on these kind of properties.
Well, then I don't have everything that's part of it, because what I have, this paragraph that you submitted, doesn't say anything about any of that. So
okay.
I'm sorry?
All I was going to say was I believe it's inherent in the whole recertification process that's what has to occur. That's why you do the recertification process. And that is a mandatory requirement that is done. I do not have any other document at my fingertips right now.
Would you like an opportunity to?
If you could provide me a week, I will try to determine if there's something on a black and white document that says ye shall execute a new lease. And if I do that, I will file it with the court.
Okay, thank you. Is that okay for you?
Yes, Your Honor.
Okay, we'll continue.
We get the opportunity to.
You will absolutely have the opportunity to respond if you find something. Yes, thank you.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm the one that needs a drink.